What is a hold harmless clause in a property management agreement? Have you ever wondered how property managers protect themselves from unexpected accidents or damages? One key tool in their arsenal is the hold harmless clause. So, what exactly is this clause, and how does it work in property management agreements? Let's break it down. A hold harmless clause is a provision in a contract that helps shield one or both parties from liability for damages or injuries. In the realm of real estate investing, particularly in property management agreements, this clause is essential. It protects landlords and property managers from being held responsible for accidents that may occur on the property. The main purpose of a hold harmless clause is to transfer the risk of liability. For example, a landlord may include this clause to ensure they are not liable for injuries or damages caused by a tenant's actions or negligence. This means if a tenant accidentally damages the property or someone gets hurt due to their actions, the landlord is not held responsible. There are two main types of hold harmless clauses you should know about. The first is the unilateral hold harmless clause. This type protects only one party, typically the landlord. For instance, a landlord may requiring a tenant to sign this clause, which protects the landlord from liability but does not offer the same protection to the tenant. The second type is the reciprocal hold harmless clause. This one protects both parties involved in the agreement. In this case, both the landlord and tenant agree not to hold each other liable for damages or injuries. This can create a more balanced relationship between the two parties. In real estate investing, hold harmless clauses come in handy in various scenarios. For tenant screening and management, these clauses can be included in lease agreements to protect landlords from liabilities that arise from tenant actions. Additionally, when it comes to property maintenance, a hold harmless clause can protect property managers from liability if maintenance issues lead to accidents. This is particularly important for property managers who may not be responsible for every maintenance task. Moreover, hold harmless agreements can work alongside insurance policies to further reduce the risk of legal liability for property owners and managers. They serve as an extra layer of protection in case something goes wrong. However, it is important to note that hold harmless clauses have their limitations. Courts may disregard these clauses if they are too broad or ambiguous. They may also not protect parties from liability for gross negligence or intentional wrongdoing. Therefore, it is vital to ensure that these clauses are clearly written and comply with local laws and regulations. Understanding how to effectively use hold harmless clauses can help mitigate risks in real estate investing. They play a significant role in protecting investments while ensuring a safe environment for all parties involved.